Joining us now, Christopher Green, law professor with the University of Mississippi Law School. Good to see you, Professor.
Good to see you.
Yes, sir. So we thought it'd be good to get you on to talk about this decision by the Supreme Court. I think it may have been just yesterday or it was Monday, where they have agreed to consider a matter that I guess would be related to the First Amendment, whether or not government officials could ban critics on social media platforms. What do you think about this? Is that the gist of the case?
That's right. So just looking at the cases that they have coming up. So we got a whole bunch of really big cases coming this term. They're going to decide, let us know what the rules are for affirmative action and for Indian law and for the website. One of the websites about weddings. Those cases are coming this term, but the cases they're granting now, these are the ones that they're going to hear by June 2024.
Okay.
And they really they don't have that many. They only have 7 cases they've granted, and 2 of them were on the same issue on Monday. So I'm always want to remind people these are actually technically 14th Amendment cases because the first word of the First Amendment is Congress. So these are local people, local school board and a local city manager who had so both Twitter and Facebook issues with blocking. And then the question is basically, it's a pretty narrow question. To what extent are they wearing, when they go on Twitter or Facebook, are they wearing a public official hat? Are they acting as the government? Is the state acting when they block these things? If they, the state can sometimes block discussion. They can remove unruly people from a place of a public discussion, but it's just this threshold question: do free speech principles apply at all? So you have two cases. It involved, so they're very long, detailed stories about what exactly was on this fellow's Facebook page. He had a lot of pictures of his dog and pictures of his family, and lists like what is your job? Well, I'm a dad to X, Y, and Z, and a husband to X, and also I'm the city manager of something. That kind of question. How much discussion about city business on the webpage has to happen before suddenly you're subject to these restraints, and you got to be nice to everybody and let people discuss things. So there's one was a city manager in Michigan. Another was a couple of school board members in California, and the cases came out the other way. So the Supreme Court, generally, you look at these cases where they agree to review things. Sometimes it's the only case like it, and they say, well, they probably are granting review to reverse. You're certainly expecting them to disagree just because they don't have to review it. Here, there were cases going both ways. They disagreed with each other quite explicitly. So it's called a circuit split between the Sixth Circuit and the Ninth Circuit. Really, it's hard to say which way they're going to go. But basically, the Ninth Circuit, as is their wont, they have sort of a much loosier-goosier test to use that looks at, well, how does it look to people? Does it look like they're acting like the school board when they have this stuff, or does it look to people like it's just a personal account? So appearance matters, and the purposes that they're using. Are they trying to campaign, or are they trying to actually do the job? That kind of stuff. The Sixth Circuit, the case for Michigan, they used a test that really looks at is the governmental authority that somebody has in virtue of having that position being used to run that Facebook account, that Twitter account. I think it was just the Facebook one and the Michigan one. But the Sixth Circuit seems like it's a little sharper, a little more like a rule, a little more like what you like the law to be. But it's hard to say what they're going to prefer.
And a lot of public officials have multiple accounts. They'll have an official account representing them in their capacity as a public official, and then they'll have a personal account. But would the courts make a distinction there? Like, okay, this is clearly your personal account. You even styled this one as whatever the title is, your office title, including your name or something. and that's a different situation, or would be subject to a different standard than a personal account. Is that a nuance they would consider?
Oh, absolutely. So I think whatever happens, it's pretty clear they're going to have some sort of totality of the circumstances analysis where that would be one of the relevant factors. It's just a question of like, well, what question are you asking about all these factors? But for instance, in remember Donald Trump? He had on Twitter, the real Donald Trump, where he had all the spicy, interesting stuff on Twitter. But then he had WhiteHouse.gov. Or not .gov, but just the White House, and it had a lot of the similar stuff. But like the real Donald Trump Twitter, the picture was this older picture, but the White House, when he was president, was him wearing a suit, looking a little more respectable. And Biden inherited the White House one. So there was litigation about. So real Donald, President Trump, when he was president, blocked people on both of these sites. Some particular group, the Knight Institute, I think, on both of these. Biden then inherited the White House Twitter handle, and by then Trump had gotten kicked off Twitter, so it ended up not being resolved back in 2021. But there was a bunch of discussion in 2021 about exactly that distinction. So you looked at back when he had both Twitter things. The White House Twitter feed said this is the Twitter feed for the White House, who is the president is at real Donald Trump. So it was like the one official website very clearly would be inherited by the next president is pointing people to real Donald Trump as the it's not clear what they're pointing to it for. Just saying who it is, or saying go over there to see what executive policy. But then you go through the tweets and you have to say, well, he's responding to foreign policy crises on that account. He speaks for the United States when he conducts foreign policy. If he's doing that on the personal account, it really certainly seems like state action. If all he's doing on the one is saying, I'm a great person to be president, rather than actually acting as president, then you could say, well, it's just a personal account. And that's a big distinction in the Ninth Circuit case, where these folks say, well, basically what we're doing is campaigning to be reelected as school board members. We're not conducting business as the school board. But the job description of a school board member is pretty fuzzy itself. So there's a bunch of complicated questions like that. But no question, like there's going to be a lot of details about, well, how many tweets in 1,000 do you have to have about official business before it's state action, and kind of thing that shows up on law school exam hypos all the time. If I were teaching a First Amendment class, you just like take these fact patterns and put them on an exam, and what would the Ninth Circuit do with the Sixth Circuit fact pattern? What would the Sixth Circuit do with the Ninth Circuit fact? Class thing to ask people. But I'm not teaching First Amendment. I don't, in case any of my students think that's going to happen. Not going to happen this spring.
So would the courts consider, I guess, the degree to which these responses, these comments, this engagement from critics in the public would rise to the level of harassment and hostility? Is that different than just being critical?
Yeah, so there's one threshold issue, which is what they're going to talk about in these cases, which is just what counts as state action. So once you say, okay, yeah, you're acting as a school board member. So the school board folks, the message, I mean, they really were pretty there were a lot of messages, hundreds of messages in 10 minutes. Sometimes you can do that under the First Amendment. There's just a lot of standard First Amendment doctrine about, when can you remove people from a limited public forum? You can have restrictions that are reasonably related to the purpose of the forum.
Sure.
Sometimes you gotta ask a question a couple hundred times before you get it answered. I would be the argument for the fellow. And you think, well, he's just he's not doing anything physically intimidating. It's not preventing other people from using the website. Let them make a couple hundred comments. You can mute the guy. This is always the thing. You could on Twitter when everybody gets blocked, you say, well, why not just mute me? Let me see your tweets. There's no reason to shut me out
to totally
of
block
the forum entirely. You don't have to listen to me.
Yeah, makes sense. Appreciate you joining us today, Professor, as always. Appreciate your insight. It's fascinating, and I'm sure we'll probably talk some more about it. Thanks for joining us.
Yeah, it's coming up. Thanks.
Professor Christopher Green with the Ole Miss Law School has been our guest here on Middays. We're coming right back. Stay with us.